Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, I actually didn't think I would be covering Alexee this week, but I was wrong. We got a few new documents that were dropped this week as far as her attorneys, her response to some of the state's motions, so we're going to go through that. So this is the Alexee Trevizo's reply to the state's response to motion to modify conditions of release. So these are all going to be from the defense responding to the state. And this was filed on August 15th. Comes now Alexee J. Trevizo and through her attorney, Gary C. Mitchell, and in reply states, allegations by the state that Alexee J. Trevizo has personally had contact with Mr. Fierro after the order of the court are false. The only time Ms. Trevizo has been in the same room with Mr. Fierro were for legal proceedings. He, for example, was in the courtroom at the hearing on conditions of release, and is expected there will be court proceedings at which both will have to be in attendance. Number two, the original order of the court allowed Ms. Trevizo and Mr. Fierro to have contact via telephone or social media, but did not allow personal contact, and each has honored the order. 3. Ms. Trevizo, not wanting to be in violation of the court order in any way, was merely trying to alert the court to the fact that both were attending college at the same university, and both would be living on campus and may be in the same classes and certainly on the same campus. Number 4, restrictions prohibiting physical contact between the two, neither of which has been convicted of any crime or misconduct, is unconstitutional in any event. New Mexico right to choose, NAR Narrow, looks like, versus Johnson, Supreme Court of New Mexico, November 25th, 1998, 126 New Mexico, 788-975, P2D841, Greco versus Oliver, Supreme Court of New Mexico, December 19th, 2013, 316 P3D 865 2013 WL6670704. Number 5, courts must safeguard and protect constitutional rights of a woman. Grego Supra. Number 6, NMSA 1978 State Statute 30 through 3-1 used by the court to prohibit physical contact between Ms. Trevizo and Mr. Fierro is not applicable in this instant. State versus Stein 1999 127 New Mexico 362-981 P2D295. And number 7, the court should allow the modifications. Respectfully submitted, Gary C. Mitchell. Yeah. I completely disagree with that, but let's continue through these motions here. Well, these replies to the state. Looks like this one here. I don't know why it's cut off slightly, but that's okay. We don't really lose anything. This one is Alexee J. Trevizo's reply to response of state to exercise of privilege, motion to suppress, motion for protection order, and Pena versus Espinoza, procedure determination. Comes now Alexee J. Trevizo by and through her attorney, Gary C. Mitchell, and replies to the state response to her exercise of privilege, motion to suppress, motion for protection order, and Pena versus Espinoza, procedure determination as follows. Number 1, the facts as detailed by the state failed to include certain key and vital facts showing the malpractice of our Teaching General Hospital and the emergency room doctor and staff, for which the hospital doctor and staff have attempted to blame Alexee J. Trevizo or Hyde. Talk about a bunch of baloney. Number 2, Ms. Trevizo, having exercised her privilege, asks the court to receive medical records and a timeline of events in a closed hearing with sealed exhibits to protect her privilege and only after a Pena versus Espinoza hearing. Well, that actually seems reasonable. Number 3, the facts are detailed in a timetable and medical records. Those records have been disclosed improperly. by the hospital, doctor, staff, and Artesia Police Department to the public. I don't believe it was the hospital. The defense, however, asks the court receive such timeline and records as an exhibit and seal those exhibits in order to protect the privilege and Pena versus Espinoza information. Number 4. The hospital doctor and toxicology records reveal certain facts that are undeniable relating to the maltreatment of Alexee and her fetus by the hospital doctor staff. Ugh. That is insulting. They're referring to baby Alex in this document as her fetus. Yeah. First, there is no question the hospital doctor staff gave her medication that caused and had a major impact on her fetus and on her. Second, they failed to honor, respect, and follow principles of care of a young woman of a childbearing years. Third, the hospital doctor staff, once knowing Alexee was pregnant based on their own lab report, continued the improper and dangerous medication. Fourth, despite knowing Alexee was pregnant, they continued to ignore basic healthcare principles when treating a pregnant woman, that is, not checking to see if she was about to give birth or birth was imminent, allowing her to go to the bathroom unassisted by medical personnel without having checked on her. She and her fetus had been receiving the medication by IV for over 1 hour and 11 minutes, according to hospital records, sufficiently long enough for her fetus to have 19 ng/ml of morphine, for example, in his system. Whew. All right, Gary. You know, this entire number 4 paragraph, that's another insult to this hospital staff. And it's also insulting to baby Alex, in my opinion. Never did this hospital not provide the best treatment they could for Alexee. It was her fault and her mom's fault, Mama Rosa, that they decided to be less than honest. And if you're honest, you get the treatment that is necessary. Like we've discussed before, so many options for her to have talked to the staff. She could have talked to the charge nurse, the doctor, or any of the other nursing staff. And she could have even talked to them without her mother present. Never did this happen. Number 5, the state misses the point. Okay? Which is to put sufficiently in as follows. A young woman still in high school who thinks she's having her monthly menses, works out at cheer practice for several hours, has major back pain that is a 10 on a pain scale of 1 to 10, with 10 being highest, finally cannot withstand the pain and asks her mother to take her to the only hospital in town, where they go. And from the time she arrives, the hospital doctor and staff ignore the simplest of emergency room principles of care when treating a woman of childbearing age, which are assume she is pregnant until proven otherwise. Do not give her medications that could impact a fetus until you know she is not pregnant. Again, let's continue to insult this staff, this medical staff, which I find to have done an amazing job considering what they were put through. And it doesn't stop from this camp, does it? It doesn't stop from Camp Alexee. It truly doesn't. Do a proper, immediate examination once you know she is pregnant. Well, Alexee wouldn't let them examine her, Gary. She would not let them touch her until after she went to the bathroom, delivered this baby, who is not a fetus. Calling it a fetus in this particular filing is very offensive. And until she delivered this baby, and they assumed it was a miscarriage, then she finally let them touch her. Then and only then. Assume she may be having a baby if she expresses she has an urgent need to defecate. No, they assume maybe she had to take a poop. Check on her and do not have her go to a public restroom if in fact you know she is pregnant, and do not let her go alone. Again, nothing is wrong with letting a pregnant person go to the bathroom alone. She had Her mother come right away to that door pretty quickly. She had the nurses outside the door. Multiple people checked on her multiple times. She was never left truly alone. Further, do not load her up on strong medications, including morphine, and expect that she is in her right mind or her fetus can be born without complications. In my opinion, she was never in her right mind. Something's wrong with her in her head, and I think the only reason she was able to deliver in that bathroom and not scream bloody murder is because of all this medication she was given. And all she had to do was ask for the help, and you know what? I think the baby Alex could have survived. That morphine was not a risk to him. Do not take advantage of her and bring police in, exercise custody of her, and not warn her of questioning designed to implicate her in a crime, especially when someone she has to trust, has a privilege with, in cooperation with police, is doing the interrogating. Well, she became a criminal from the time that they discovered that she decided to throw her baby in a trash bag, double tie it, and hide it. That's a crime, Gary. That is a crime. Number 6, the state submits HIPAA does not preclude medical providers from disclosing information to police for a crime committed on the premises. Such can be an exemption, but only if a crime was committed, which it was. HIPAA prohibits a, quote, covered entity, unquote, from using or disclosing protected health information. 45 CFR, State Statutes 164.502A. Covered entities include a, quote, health plan, unquote, a, quote, healthcare clearinghouse, unquote, and a, quote, healthcare provider who transmits any health information in electronic form in connection with a transaction, unquote. That HIPAA covers 45 CFR, State Statutes 164.104A, United States versus Yazzie, United States District Court, D. New Mexico, February 6, 2014, 998F, Supplemental 2D, 1044. Number 7, HIPAA does not have a suppression remedy, and where this is the case, it is inappropriate for the court to exclude evidence on this basis. United States versus Streets, 560 F3D 926 935 9th Circuit 2809 Clientsfield J. Occurring. HIPAA does not provide any private right of action, much less a suppression remedy. The defense is not asking for a suppression remedy under HIPAA, but using HIPAA along with the doctor-patient privilege in New Mexico to point out that not only does this state law and federal law protect a patient's privilege in medical information. I think that they followed HIPAA very to the cuff and once it became a crime, kind of changed a lot of things, you know? Number 8, Alexee did not waive any privilege. One has to seriously question whether she was ever informed she had a privilege. Most important, with police in the room, she was never informed she had the right to remain silent and have a lawyer, which should have been done immediately. In Alexee's case, the doctor, her treating physician, and the police went into the room after the deceased child had been found with the purpose of challenging her about the deceased baby. She was not free to leave, and police were armed and in the room. Plus, she was in dire medical condition, later flown to Roswell for medical treatment. This type ploy has been done before and held irrepensible. In Miranda versus Arizona, Supreme Court of the United States, June 13th, 1966, 384 United States, 436, 10 Ohio, miscellaneous 9. Federal agents giving of warning alone was not sufficient to protect defendant's Fifth Amendment privilege, where federal interrogation was conducted immediately following state interrogation in the same police station and in same compelling circumstances after state interrogation in which no warnings were given, so that federal agents were beneficiaries of pressure applied by local in-custody interrogation. Wow, he's quoting way back to the 60s on this one. course, I'm not familiar with it either, but that'd be something to look up. A defendant is subjected to an interrogation for Miranda purposes whenever police officers expressly question a defendant or expose him to the functional equivalent of questioning. I don't believe they actually questioned her. They only told her that she was not free to leave. I didn't hear any questioning happening, except they told her that the detectives were on the way. The hospital wanted her to be flown out to another facility to make sure she wasn't still bleeding, and they wanted to make sure she was safe. So I don't recall them ever asking her any questions, at least not those officers. State versus Contour, Court of Appeals of New Mexico, April 21st, 2009, 146 New Mexico 649213 P3D 799. See also Missouri versus Seibert, Supreme Court of the United States, June 28th, 2004, 542 U.S. 600124, S. Court 2601159 L. ED 2D 643. Miranda warnings given mid-interrogation and after defendant gave unwarranted confession were ineffective, and thus confession repeated after warnings were given was admissible at trial, abrogating United States v. Orso 266 F3D 1030 and United States v. Esquilin 208 F3D 315. The Miranda safeguards come into play whenever a person in custody is subjected either to express questioning or to its functional equivalent. For Miranda purposes, the term interrogation refers to any words or action on the part of the police other than those normally attendant on arrest and custody that the police should know are reasonably likely to elicit an incriminating response from the suspect. Rhode Island versus Innis, Supreme Court of the United States, May 12, 1980, 446, United States 291, 100, S. Court, 1682. Again, they never questioned her, and she never really said much except she said to her mother and to the doctor, it wasn't breathing or nothing. It wasn't crying. That was pretty much the extent of what she said. Number 9. Before they begin custodial interrogation of a suspect, the police have an obligation to deliver Miranda warnings. People v. Leonard, 2007, 40 Cal 40th, 1370, 1399, 1400, 58, Cal Repeat, 3D, 368, 157, P3D, 973. A handful of courts have discussed custody and Miranda application in a medical setting. See People v. Mosley, 1999. Gotta skip some of these numbers because it's tongue time, you guys. And the other cases are United States v. Martin in 1985. Looks like there's another one, United States v. Robinson, 1994. United States v. Jameson in 2007. United States v. New in 2007, Wilson versus Kuhn, 1987, and Reinhardt versus Larkins in 2004. The totality of the circumstances is used to determine whether the defendant's will has been overborne and his or her capacity for self-determination critically impaired by coercion or trickery. Courts consider the presence of police coercion is necessary, but not always a sufficient element. Courts also consider other factors such as location of the interrogation's continuity, as well as the defendant's maturity, education, physical condition, and mental health. People v. Caro and Mincy v. Arizona. So, her maturity is in question. Her education is pretty good. And as far as her knowledge of stuff, I think she knows a lot. Let's see, the High Court, looks like here, they're going through those cases here. The High Court determined that a suspect did not give voluntary statements after an officer engaged in a virtually continuous questioning of a suspect rather, who had requested to be left alone. While a defendant's compromised physical and psychological condition alone will not render her statements involuntary, People v. Puna, 2005, that condition is relevant to the inquiry and presents an opportunity for abuse. She never asked to be left alone. She never said anything like that. Number 10, a similar case for the facts in Alexee's case occurred in Arizona, United States versus Welsh, in United States District Court in March 13, 2017. Not reported in federal. It looks like the admission of statements she made to an examining doctor on the night in question would violate her Miranda rights and the Fifth Amendment privilege against compelled self-incrimination. Police in the Welsh case knew the treating doctor would ask what happened, and when she did, were present and listened. No Miranda warnings had been given. In Alexee's case, the doctor participated in the ploy to get Alexee to say what happened, and the doctor and police worked together to make certain this would happen in their presence, and with Alexee forbidden to leave by police. As the court noted in Welsh, the examination by the doctor was the functional equivalent of express police questioning. Yeah, because the doctor and the police just said, hey, let's twiddle our thumbs here and let's go in there and trick her into confessing that the obvious deceased child in the trash can is hers. And then let's tell her she can't leave. She couldn't leave. Yes, there was an investigation pending, but she couldn't leave because she needed further medical care. That was paramount, and the doctor was very clear on that. Number 11, the voluntariness of in custody unwarned statements to a doctor was addressed in Estelle v. Smith, 1981, where the trial court had ordered the state to arrange a psychiatric examination of the defendant to determine his competency to stand trial. At the penalty phase of the trial, the state used the defendant's statements to the doctor to establish his future dangerousness. In finding that the use of the statements violated the Fifth Amendment right against self-incrimination, the court pointed out that the purpose of the Miranda warnings was to combat what the court saw as inherently compelling pressures at work on the person and to provide him with the awareness of the Fifth Amendment privilege and the consequences of foregoing it. The court should suppress statements given in front of police when the doctor interrogated her. I'm a little not sure that this is going to fly completely. Because, yes, the doctor said we found a baby in the trash. But it wasn't really an interrogation. They were just giving her the facts. So I think that's a little on the border. Again, I'm not a lawyer and I don't play one on TV. Number 12, Alexee J. Trevizo had a privilege. She never consented to release her protected medical records and information. She was not given Miranda warnings when police came into her room to prevent her from leaving and take custody, and police working with her doctor, unknown to Alexee, had her doctor interrogate her as to what happened. Further, the court should first determine the extent of the privilege, what medical records, if any, could be disclosed, suppress the statement made by Alexee, and because the privilege was violated, exclude all evidence wrongfully obtained by violating the privilege. And of course, it's respectfully submitted by Gary C. Mitchell. So basically, he's obviously still questioning all the records release. That's the main huge part, but he is wanting any of the statements that were made when the doctor, the staff called and the police came in with their body cams on, and the doctor told her that we found a deceased baby in the trash. So they want to disclude that entire, well, basically probably the entire body cam. And I don't think that's going to happen. At least I hope that's not going to happen. But they're stating that because of all this, her rights were violated. I don't believe that that's the case. She could have at any time said, I'm not saying anything. I don't want to talk. and I don't know anything about it, which is pretty much kind of what she alluded to, except that she said it just came out of me and nothing was crying. Because I believe Mr. Mitchell knows that is super, very incriminating for her. The fact that she said nothing was crying. So she admitted that she did it in that way. So those are the current documents, the responses from Alexee through her attorney, Mr. Gary Mitchell. So I think, again, he's trying any and all avenues he can. He wants anything he can do to let this girl off and have to take any responsibility for her actions. And it's disgusting. It truly is disgusting. I don't know, guys. It's the more and more documents that get dropped, it baffles my mind how there's just zero responsibility being taken by this girl. It's sad. And further, I'm concerned how they refer to baby Alex as the fetus numerous times. And he was a real alive being. Even though he may have only been here for a very, very short time, he was real and he was alive. At least until Alexee got her hands on him. It's just disgusting. Alright, guys, let me know what you think in the comments of the new updates and the response by Alexee and her team, her legal team. And with that said, that's all I've got. I hope you guys have a great rest of the day. And most of all, stay safe.